Hello guys, welcome back to Tina Do Children Law Update family. Thank you all so much for pulling up and supporting this channel. You are all amazing. Today we have something quite interesting. It's section 31.2, which is otherwise called threshold for those who do children law in England and Wales. We're quite familiar with it, but we bring it today in a different format. We put some background music to it just to see how you will enjoy it. If you have an opinion on this, please put it in the comments, and we will see whether the next production we will avoid putting background music. I know you will enjoy it, and it's really beautifully put together. And yes, let's.
Hello friend, today we're going to examine the meaning of significant harm in the context of Children Act 1989 and how it relates to threshold for the purpose of the public law outline. We will also look at what is not significant harm. A public authority should not instigate public law outline unless it is satisfied that there are reasonable grounds for believing that the circumstances with respect to the child are as mentioned in section 31 subsection 2 of Children Act 1989. The threshold set by section 31 subsection 2 of the Children Act 1989 requires that the court be satisfied, open brackets, close bracket A, that the child concerned is suffering or is likely to suffer significant harm, and open brackets, close brackets B, that the harm or likelihood of harm is attributable to, open brackets, close brackets, 1, the care given to the child or likely to be given to him if an order were not made, not being what it would be reasonable to expect a parent to give to him, or open brackets, close brackets 2, the child's being beyond parental control. Lady Hale in 2013 in a Supreme Court case in Re B, a child, FC, reported in 2013 UKSC from page 33, reviewed some threshold cases such as real care threshold criteria reported in 2007, 1 FLR from 2050. Lady Hale gave guidance on what is significant harm. In this video, we shall be considering the guidance given in the judgment. By section 31, subsection 9 of the Children Act 1989, harm, as in HARM, means ill treatment or the impairment of health or development, including, for example, impairment suffered from seeing or hearing the ill treatment of another. Ill treatment includes sexual abuse and forms of ill treatment which are not physical. Health means physical or mental health, and development means physical, intellectual, emotional, social, or behavioral development. There is no definition of significant, but section 31 subsection 10 of Children Act 1989 provides that when a question of whether harm suffered by a child is significant, turns on the child's health or development. His health or development shall be compared with that which could reasonably be expected of a similar child. Thus, while the standard of parenting expected by section 31 subsection 2b is the objective standard of a reasonable parent, the level of development expected of the child is the subjective level to be expected of a child like him. Mumby J said in K, a local authority, and N, and another, a case reported in 2005, EWHC, from page 2956. Also reported in 2007, 1 FLR 399 at paragraph 26. Mumby J said, the court must always be sensitive to the cultural, social, and religious circumstances of the particular child and family. Before the Children Act came into force, the courts have recognized that there is a line to be drawn between parents whose personal characteristics mean that they may be less than perfect parents and parents who may cause harm to their children. Lord Templeman put the point this way in his well-known words in the case Re KD A minor Ward termination of access, reported in 1988 AC, from page 806, particularly at page 812. Lord Templeman said, the best person to bring up a child is the natural parent. It matters not whether the parent is a wise or foolish, rich or poor, educated or illiterate, provided the child's moral and physical health are not endangered. Public authorities cannot improve on nature. Lady Hale reasoned that if by that sentence Lord Templeman was making a factual statement, then some might disagree. If a local authority or if local authorities remove children from unsatisfactory parents at birth and swiftly place them with highly satisfactory adoptive parents, they can undoubtedly improve on nature. But in Lady Hale's view, Lord Templeman was making a normative statement, which is that public authorities have no right to improve on nature. That thought has been followed through in numerous cases since, as Wall LJ pointed out in Riel Children Care Proceedings Significant Harm, reported in 2006, EWCA CIV, from page 1282. Also reported in 2007, 1 FLR 1068 at page 1084, where Wall LJ said, there are, of course, many statements in the law report warning of the dangers of social engineering. In another case, Butler Sloss LJ, in Rio A minor, custody, adoption, reported in 1992, 1 FLR, from page 77, particularly at page 79, where Butler Sloss LJ said, if it were a choice of balancing the known defect of every parent with some added problems that this father has against idealized perfect adopters. In a very large number of cases, children would immediately move out of the family circle and towards adopters. That would be social engineering. Riel is an important case because it concerned parents with learning difficulties. Very considerable in the case of the mother. The judge had found significant harm on the basis of the report of a psychologist who had not been asked to assess this. She had acknowledged that there was no obvious harm, no explicit malicious abuse or extreme abuse. The judge said, "On the contrary, my concern in this family relates to the more subtle and ambiguous consequences on the children flowing from parents' deficiencies." Wilson L.J. commented, "So which was it? Significant harm or subtle and ambiguous consequences?" Lady Hale regards the two concepts as mutually exclusive. For these and many other concerns about the report, the case was sent back to be reheard in the High Court. In Riel, care threshold criteria reported in 2007 won FLR from page 2050, particularly at page 2063. Hedley J., having quoted Lord Templeman, said, "It follows inexorably that society must be willing to tolerate very diverse standards of parenting, including the eccentric, the barely adequate, and the inconsistent. It follows too that children will inevitably have both very different experiences of parenting and very unequal consequences flowing from it. It means that for some children, they will experience disadvantage and harm, while others flourish in atmospheres of loving security and emotional stability. These are the consequences of our fallible humanity, and it is not the province or provenance of the state to spare children all the consequences of defective parenting. However, there are some consequences of defective parenting that children must be protected from, and that is why some of those children are removed. The difficulty is to identify what it is that tips the case over the threshold. Although every parent, every child, every family is different, and as Hedley J. put it, significant harm is fact-specific and must retain the breadth of meaning that human fallibility may require of it. There must be some consistency in the approach of both local authorities and the courts. Hedley J. went on to say that it must be something unusual, at least something more than commonplace human failure or inadequacy. It does appear that he considered that the children were suffering and likely to suffer some harm to their intellectual development as a result of their parents' inadequacies, but that it was not of a character of significance to justify the compulsory intervention of the state. The Court of Appeal wrestled with the problem of separating harm from significant harm. In the case of Re MA, care threshold reported in 2009, EWCA CIV from page 853, also reported in 2010, won FLR from page 431. The trial judge in this case had found that although the parents had ill-treated another child, whose presence in the house remained something of a mystery, their own children were well cared for, healthy, well nourished, and had strong bonds with their parents. The eldest child had been slapped, kicked, and hit on the head by one of the parents or one or other of her parents, but that was not significant harm. Wilson L.J. at paragraph 29 quoted Booth J. in Humberside County Council versus B, reported in 1993, 1 FLR from page 257, particularly at page 263, where Booth J. said, significant harm was defined by Ms. Black in accordance with the dictionary definition. First, as being harm that the court should consider was either considerable or noteworthy or important. Then she expressed it as harm which the court should take into account in considering a child's future. Wilson L.J. went on to comment that while I might not have expressed myself in quite such broad terms, they certainly foreshadow the view of Lord Nichols expressed 3 years later, that, in relation to the likelihood of harm, the threshold is set at a comparatively low level. In the same case, Ward L.J. emphasized correctly that Lord Nichols' remark in Re H, reported in 1996, AC 5 from page 563, was directed not at the threshold as a whole, nor at the threshold of significant harm, but at the threshold of likelihood of harm in the future. Lord Nichols said nothing in that case or in any later case to suggest that the threshold of significance was comparatively low. Ward L.J. went on at paragraph 54 to express the difference between harm and significant harm in this manner. Given the underlying philosophy of the Act, the harm must, in my judgment, be significant enough to justify the intervention of the state and disturb the autonomy of the parents to bring up their children by themselves in the way they choose. The point can therefore be made both of this definition and of the second of the two definitions suggested by Ms. Black to Booth J. that they are somewhat circular. The state is justified in intervening if the harm is sufficient to justify the state's intervention. But it serves to make the point that not all harm which children may suffer as the result of their parents' care falling short of what it is reasonable to expect is significant for this purpose. The dictionary definition, considerable, noteworthy, or important, is extremely helpful. It chimes the guidance given by the Department of Health and Social Security when the Children Act 1989 first came into force. It is additionally necessary to show that ill treatment is significant, which given its dictionary definition means considerable, noteworthy, or important. There would be no point in the threshold if it could be crossed by trivial or unimportant harm. As to the suggestion made by Ward L.J. that Article 8 of the European Convention on Human Rights does inform the meaning of significance. Lady Hale agrees that it is only the court's order and not its finding that the threshold had been crossed which constitutes an interference with the Article 8 right. However, the reason why the threshold is crossed forms part of the court's reason for making the order, and thus must be relevant and sufficient. It is not sufficient that the child will be better off in another family. That is the reason for the existence of the threshold, which was substituted for the more precise criteria laid down in the Children and Young Persons Act 1969 and the Child Care Act 1980. Furthermore, there is a relationship between this debate and the approach taken to proportionality. If permanent removal is proportionate, if it is the only way of avoiding the identified risk of harm, then it is also important that the threshold of harm is not set at low a level, for otherwise the reason for removal will not be sufficient. Say, for example, that it is highly likely that a child will turn into an unhealthy couch potato like her parents, and only permanent removal could reliably prevent this. It would nevertheless not be a justifiable interference with family life to permit this. Added to the difficult question of identifying significant harm, is the question of identifying the degree of likelihood that such harm will be suffered in the future, which is necessary to take the case over the threshold. It was held, albeit strictly obiter, in Re-H, Minors, Sexual Abuse, Standard of Proof, reported in 1996 AC from page 563, that likely does not mean probable or more likely than not. Likely, in Lord Nichols' well-known words, means a real possibility, a possibility that cannot sensibly be ignored, having regards to the nature and gravity of the feared harm in the particular case. That standard has been adopted or approved in numerous later cases, including recently in this court, in the Supreme Court, in Re-J, Children, Care Proceedings, Threshold Criteria, reported in 2013, UKSC from page 9, also reported in 2013, 2 WLR from page 649. It is in this respect, and this respect alone, that Lord Nichols observed that the threshold is comparatively low. The reason for adopting a comparatively low threshold of likelihood is clear. Some harm is so catastrophic that even a relatively small degree of likelihood should be sufficient to justify the state in intervening to protect the child before it happens. For example, from death, or serious injury, or sexual abuse. But it is clear that Lord Nichols did not contemplate that a relatively small degree of likelihood will be sufficient in all cases. The corollary of the more serious the harm, the less likely it has to be, is that the less serious the harm, the more likely it has to be. Of course, another reason for adopting a test of real possibility rather than more likely than not is that it is extremely difficult to predict the future, and to do so with a sort of accuracy which would enable a court to say that it was more likely than not that a parent will harm a child in the future. Once again, this is a particular problem with emotional or psychological harm, which may take many years to manifest itself. The Children Act does not set limits upon when the harm may be likely to occur, and clearly the court is entitled to look to the medium and longer term as well as to the child's immediate future. However, the longer term the prospect of harm, the greater the degree of uncertainty about whether it will actually happen. The child's resilience or resistance and the many protective influences at work in the community, whether from the wider family, their friends, their neighborhoods, the health and social services, and perhaps above all, their schools, mean that it may never happen. The degree of likelihood must be such as to justify compulsory intervention now. For there is always the possibility of compulsory intervention later, should the real possibility solidify. The second element in the threshold sheds some light upon these questions. The harm or the likelihood of harm must be attributable to the care given to the child, or likely to be given to him if an order were not made, not being what it would be reasonable to expect a parent to give him. And that's in section 31 subsection 2b of Children Act 1989. This reinforces the view that it is a deficiency in parental care rather than in parental character which must cause the harm. It also means that the court should be able to identify what that deficiency in care might be and how likely it is to happen. Allied to this is the definition of harm itself. It is wide, but it is not infinite. The focus is upon the child suffering that harm. So upon the child suffering ill treatment or suffering the impairment of her health or development, ill treatment will generally involve some active conduct. Whether physical or sexual abuse, bullying, or other forms of active emotional abuse, other forms of active emotional abuse. Impairment may also be the result of active conduct towards the child, but it could also be the result of neglecting the child's needs for food, for warmth, for shelter, for love, for education, for healthcare. Generally speaking, however, the harm is likely to be the result of some abusive or neglectful behavior towards the child. But this is not invariably the case, as is shown by the inclusion by way of example, impairment suffering from seeing or hearing the ill treatment of another. We now know that serious harm may be done to the development of children who see or hear domestic violence between their parents. It is the statute and the statute alone that the court have to apply, and that judicial explanation or expansion is at best an imperfect guide. Lady Hale said in her guidance, "Parents, children, and families are so infinitely various that the law must be flexible enough to cater for frailties as yet unimagined, even by the most experienced family judge. Nevertheless, where the threshold is in dispute, courts might find it helpful to bear the following in mind. Number 1. The court's task is not to improve on nature, or even to secure that every child has a happy and fulfilled life, but to be satisfied that the statutory threshold has been crossed. When deciding Number 2. When deciding whether the threshold is crossed, the court should identify as precisely as possible the nature of the harm which a child is suffering or is likely to suffer. This is particularly important where the child has not yet suffered any, or any significant harm, and whether the harm which is feared is the impairment of intellectual, emotional, social, or behavioral development. Number 3. Significant harm is harm which is considerable, noteworthy, or important. The court should identify why and in what respect the harm is significant. Again, this may be particularly important when the harm in question is the impairment of intellectual, emotional, social, or behavioral development which has not yet happened. Number 4. The harm has to be attributable to a lack or likely lack of reasonable parental care, not simply to the characters and personalities of both the child and her parents. So once again, the court should identify the respect in which parental care is falling or is likely to fall, short of what it would be reasonable to expect. Number 5. Where harm has not yet been suffered, the court must consider the degree of likelihood that it will be suffered in the future. This will entail considering the degree of likelihood that the parent's future behavior will amount to a lack of reasonable parental care. It will also entail considering the relationship between the significance of the harm feared and the likelihood that it will occur. Simply to state that there is a risk is not enough. The court has to be satisfied by relevant and sufficient evidence that the harm is likely. I hope you have found the guidance given in this video useful, and I hope you now have a better understanding of the meaning of significant harm and how it applies in relation to children when considering the section 31 subsection 2 of in relation to safeguarding the welfare of children. Should you have any comments, please send us your comments and feedback and any topics you want us to consider. And also, should you wish to view other videos, please visit www.tinedu.co.uk, or you can view other videos on Tinedu on our channel called Tinedu on YouTube. You can also view videos on our Facebook channel, and also go into our Twitter account.